Welcome to Arbitration Essentials for In-House Entertainment Counsel. I'm David Schraga, Secretary of the Beverly Hills Bar Association's Entertainment Law Section. The Entertainment Law Section itself is sponsored by Lawyers Mutual Insurance Company. For 5 decades, Lawyers Mutual has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that Lawyers Mutual is directed by a group of dedicated lawyers themselves. They offer special rates with competitive premiums for a wide range of areas of practice, including entertainment law. Learn more at lawyersmutual.com. I am delighted to now introduce our speakers, Aaron Gothelf, Adam Heim, and Andrew Prout. Aaron Gothelf is the Regional Vice President of the American Arbitration Association's Commercial Division for California. He serves as the National Chair of AAA's Entertainment Practice, the Western U.S. Chair for AAA's Technology Practice, and as an ambassador for the AAA ICDR Foundation. Aaron is a council member for the ABA's Dispute Resolution Section, of which he formerly served as Educational Programming Officer. He's also the chair of the ABA's Forum on Entertainment and Sports Industries, Motion Picture and Television Division, a member of the ADR Committee for the Litigation Section of the California Lawyers Association, as well as a rotating host for the ABA podcast series Resolutions. Adam Heim is Executive Vice President of Business Affairs and Deputy General Counsel at Fifth Season, formerly Endeavor Content, a global entertainment studio whose projects include Severance, Nine Perfect Strangers, and Tokyo Vice. He leads their studio's scripted television and feature film business and legal affairs practice, overseeing studio licenses, co-productions, rights acquisition, and talent agreements. And he also oversees the studio's intellectual property and litigation practice group. Adam has been recognized as a leading Hollywood dealmaker by Variety and as one of Hollywood's top entertainment attorneys. Andrew G. Prout is a managing partner at Ross Wolcott LLP. He's an experienced first-chair trial lawyer and litigator who has led more than 10 trials and arbitrations involving claims exceeding $250 million. In recent years, he's obtained over $100 million in plaintiffs' verdicts and settlements, including a $39.4 million arbitration award confirmed in federal court. His practice spans complex civil litigation, trial strategy, and dispute resolution. Before joining his firm, Andrew clerked for Judge Timothy M. Timkovich of the United States Court of Appeals for the 10th Circuit. And now, let's get started.
All right. Thank you very much, David, for the wonderful introduction. Appreciate that. I still see the panel up. Are people still voting, or what do I do? Oh, now it's gone. Okay. Well, thank you very much for the folks that participated in the poll. A little bit about the presentation today. So I had done a similar presentation as a modification of the program that some of you have seen on arbitration efficiency, just for general commercial counsel, both in-house and outside. And I figured, why not for the Beverly Hills Bar Association do one specifically for entertainment counsel? So whether you're in-house counsel, whether you're outside counsel, or a neutral, this is going to give you kind of an idea of how everybody kind of works together. Next slide. So has arbitration become general litigation? So the first thing is you have to understand, what is the point of arbitration, right? So arbitration is supposed to be a faster, more cost-efficient way of resolving disputes than traditional court. That is why people put arbitration provisions into contracts. But in recent years, we have started to see arbitration kind of blend into litigation. Exotic discovery, asking courts to intervene with certain issues, requiring a 3-arbitrator panel when the dispute's relatively small and probably doesn't require that, extended evidentiary hearings, whatnot. So the goal is to try to get away from that, right, and try to rein back in arbitration into the efficient way of resolving disputes that we've always known it as. Next slide. All right. So I usually like to go, and before we're going to go into talking with Adam and Andrew, just to quickly talk about what a well-drafted arbitration clause looks like and how that is the basis, basically, for an efficient arbitration to restore arbitration's promise. So what happens when we have a poorly drafted arbitration clause? So I like to give this kind of image. You might draft a 600, 700-page contract. I don't care how long it is, right? And buried somewhere on page 82, clause C3 is one really poorly drafted sentence, which is the arbitration provision. It doesn't make any sense. It's missing important information and whatnot. And you might not think about it when you entered into the contract. But that little poorly drafted arbitration provision is like a crack in your windshield going down the road when a pebble hits it. It's not a big deal when it happens, but that crack is going to continue to get bigger and bigger and bigger throughout the life cycle of the contract, especially if there's an issue. So eventually that windshield is going to crack all the way across the side. So what do we have here? A poorly drafted arbitration clause, failure to meet the parties' expectations, right? Well, what were the expectations? A faster, more efficient way of resolving your dispute than going to court. Costs that quickly spiral out of control with the advantage going to the side that has more money to spend on the process. Arbitration was never designed to give an advantage to the side that could spend more money on the process. It's supposed to be fair for both sides, regardless of their ability to pay for it. And then ultimately, the goal usually is one side to force the other side into a less than desirable settlement agreement. Unnecessary court intervention, of poorly drafted arbitration provision that's ambiguous and doesn't set out the process for the case, often ends up in court. One side's going to file a TRO to stop the arbitration, ask a judge to clarify things. Again, you shouldn't have to use court for anything in an efficient arbitration, and this is just an example of where that happens. And of course, the arbitration process itself being blamed for the unfortunate result, not the poorly drafted arbitration clause. Next slide. All right. So when you're drafting an arbitration clause, you want to draft the one that's going to fit your business. So types of arbitration clauses and the ones that typically lead to cost overruns. So we talked about the 1 versus 3 arbitrator issue. I'm a big fan of arbitrations being heard by a single arbitrator. A third, 3 arbitrators is typically 4 to 5 times more expensive. You say, Aaron, why isn't it 3 times more expensive? Well, the chair is going to bill a lot of extra time, typically supervising the work of the wings. And for relatively small disputes, this isn't necessarily required. Now, in entertainment contracts, let's say you have a film or television profit participation contract, or you have a film financing agreement, something like that, where you might be dealing with tens of millions or hundreds of millions of dollars. If you feel better having 3 arbitrators than a single arbitrator, just to have some extra eyes in the case, by all means, go about do that. But if this is like a small kind of independent contract where the amount in controversy is not going to be that much, you might want to think about that. Deciding which arbitrations rules to apply and the type for your business type. So one thing that we run into at AAA a lot is people simply drafting into a contract the American Arbitration Association rules or according to the AAA rules. Well, those rules, we have lots of different rules. We've got employment rules, we've got commercial rules, we've got construction rules, consumer rules, etc. So in entertainment, especially in the film and television world, most rule sets are going to fall under the commercial rules. You want to be specific about that. But as Andrew will tell you, or Adam will tell you, sometimes you might have an employment contract or something like that, right? Then you want to be specific about the employment rules. The type of rules you use are very important because if they determine who's responsible for paying for the arbitration, they can put limits on discovery. They can impact whether it's going to be heard by a single arbitrator or a panel of 3 arbitrators, all these different things. So it's important to know that. Arbitrator qualifications in the selection process. Obviously, entertainment is a very specific niche area of law. You might want to put some qualifications in there that someone has, as an attorney, 10 plus years handling profit participation disputes, for example, or 10 years or 20 years of experience handling disputes between talent and management, whatever the entertainment contract's for. There are some people out there that are be like, I don't care if they have any experience in the subject matter area. I just want a retired judge to hear it or something like that. I don't think that's always the best thing. When you don't have somebody that's an expert hearing your case in the subject matter, it's going to lead to cost overruns and a lot of questions and clarification, and you might not get the right result at the end. Deciding whether it's going to be a single arbitrator or a panel of 3 arbitrators. Obviously, we addressed that earlier. And then the governing law. How would the governing law or choice law provision impact your arbitration? This is particularly important when you have a contract between parties in 2 different states or even 2 different countries, right? So you're going to want to specify whose state's governing law, not just the substantive governing law, but the procedural law will impact the arbitration. In California, for example, we use the California Arbitration Act. Different states have different acts. The Federal Arbitration Act is the overall national act, but states have other stuff. And then deciding on the location of the evidentiary hearing, I always say one city, one state, one city, one country. Do not give people multiple options in the arbitration provision, because if the options are New York and Los Angeles, and one party is in New York and one party is in Los Angeles, well, guess what's going to happen? One party is going to demand New York, the other party is going to demand Los Angeles. There's going to have to be briefing on the issue. You're going to have to bill your client a lot, charge your client a lot more money, obviously, to sort out this issue. It's all a waste of time, right? So one city, one state. All right. So enough about me talking on this slide. It's time to get to the questions. We have our first questions here. Andrew, what's your experience using a single arbitrator versus a panel of three arbitrators? Does the cost justify the result?
Thanks, Aaron. I think you hit the nail on the head with the excessive costs that can sometimes accrue in a smaller case when you have a panel of three. In my experience, the panel of three, when you're talking about larger disputes, 50 million plus or 100 million plus, those are the types of disputes where the cost, I think, is merited. But when you have a smaller dispute below those types of thresholds, I think one arbitrator is the way to go. The scary thing when you're going into arbitration is the arbitrator has quite a bit of power because of the limits on the ability to review the decision. And so when the case gets large enough, I do think that there is some merit in having three. And I think that the process of how you select the three is also important, because I've been in situations where you have each party picks one and then the two pick one, and that can often create a dynamic that is not as conducive to truly having three neutral panelists to hear the issues and shepherd the dispute towards resolution. So I agree with what you said, Aaron, and generally would go with one unless it's a larger dispute.
Adam, I got actually two questions for you. The first one is just typically how involved would you be in the selection process working with outside counsel? Do you mainly just leave it up to them because they knew who they like, they know who they've worked with in the past, whatnot? And then the second one is, how important do you think having entertainment expertise is important in the arbitrator qualifications, or do you believe in the old adage, any old judge probably could understand the subject matter?
Yeah. Well, thank you, Aaron, first off, for having me on the panel today. I'll answer the second question first. In my view, for most of our arbitrations, entertainment isn't introducing very many complex issues. We see a lot of the same issues that arise in other commercial contexts. And so we haven't generally included entertainment expertise in the arbitration clause because we have come to expect there's a lot of crossover with general commercial litigation arbitration, and also because every dispute introduces different issues. When we are, though, to answer your second question, when we are at the stage of selecting an arbitrator, we'll know more about our dispute at that point. And more often than not, we are generally leaning into selecting an arbitrator that has some background in entertainment matters. We should have a pretty good understanding by the time that we're actually in the process of selecting an arbitrator, what some of the strengths and weaknesses of our position is going to be in the arbitration. And some of that can determine who the arbitrator is, and whether or not the depth of their specific expertise in entertainment.
Yeah.
For example, if we feel like a core strength in our case is something that's very unique to entertainment, then it's really nice to know that you have an arbitrator who's very familiar with those issues. I guess I haven't experienced this myself, but I guess the opposite could also be true, that if you feel like your core strengths of your case are on more general commercial issues, and that maybe the other side's going to introduce an issue that's much more specific to the entertainment context, then it might be nice to have somebody who's, as an arbitrator, who's got more of a core general commercial legal background. And it doesn't bother you as much if the person doesn't have as much expertise in entertainment. All that being said, I hire who I consider to be the best outside counsel, and I trust them a lot in this. I'm involved in it. I'll participate in it, but ultimately, 99% of the time, I'm going to defer to outside counsel on the ultimate selection of the arbitrators or arbitrator.
Excellent. Okay, and then I guess a question for either one of you, probably more directed at Andrew. Do you care more about an arbitrator with specific subject matter expertise that's, say, an attorney arbitrator, or do you feel it's more important for them to have a judicial background, just a general judicial background? If,
I do prefer the general judicial background. In the mediation context, I go the other way. I tend to
okay.
like the subject matter expertise, but in the arbitration context, I do like the former judges.
All right, that's interesting. Yeah, no, I think that makes a lot of sense, especially because the mediation, you're just about trying to get the parties to come together and work out an issue on their own. And sometimes having a neutral who has a lot of expertise in an area can almost do what we call an early neutral evaluation, right? Kind of say, I've seen this case dozens of times, hundreds of times before. I've tried this case. In my experience, this is what would happen if it goes to trial. So thank you guys very much for your answers. Okay, next slide. All right, so a couple of just different things going down the list of things that can be added. So issues with confidentiality, will the award be made public? A lot of people might be raising an eyebrow at this part because you assume that all arbitration awards are confidential. And the general presumption is that arbitration is a confidential process, but there are always going to be situations where, for example, the law might require disclosure. For example, if you are a publicly traded company and you have just gotten a very, very large arbitration award, you might have to report where that income came from to shareholders, for example, right? That's an SEC reporting. And you don't want something drafted into the provision that conflicts with the law, because again, that's going to create issues and cost money to sort out. How will the discovery process be handled? The discovery process tends to be the longest, most complicated part of the process, oftentimes a lot more complicated than the evidentiary hearing itself. We talked about one side trying to bleed the other side financially out by requesting lots of worthless depositions. In other types of arbitrations, maybe a site visit, document production that doesn't make any sense. They need tens of thousands of pages of various documents produced. And, I've seen in arbitration provisions it drafted saying, like, listen, unless the amount at stake is over a certain dollar threshold, both sides are limited to depositions, right? Or both sides are limited to a handful of interrogatories, whatnot. Sometimes that makes sense. Remedies, including emergency relief. This is not going to be a program today on quote unquote emergency arbitration, but there should always be, I think, in a larger case, especially if something is time sensitive, something that gives an option for an immediate decision on some part of the case that's time sensitive, not necessarily the merits in the whole case, and that's what emergency arbitration is. This is something that's often missing from a lot of provisions. Sometimes it's covered by statute, sometimes it's covered by case law, is the assessment of attorney's fees and other costs of the arbitration, also known as a prevailing party or cost shifting provision. There's a general presumption that if you win in arbitration, a commercial arbitration, that the winning side is entitled to recover their attorney's fees and other costs. That's not always true. I've seen provisions that say everything is going to be split 50-50 and nobody gets attorney's fees and costs. I've seen provisions that are silent on it. I've seen attorneys try to argue when it's silent that law requires them to get the attorney's fees back, or case law or whatnot. So again, that's going to be another issue that you have to argue about if it's not spelled out in the provision. So that's something just to keep aware of. And lastly, and then the other thing too, I would say is if you do intend for the winning party to get their costs covered, be very specific. Oftentimes it'll say they're entitled to get their attorney's fees, and the winning side submits a fee application that includes attorney's fees, the deposits paid to the arbitrator, any administrative fees paid to the ADR institution, their hotel rooms, their meals, their plane tickets, basically all this stuff, right? And the arbitrator has to say, wait a second, it just says attorney's fees here. Why are you asking for all this other stuff? Again, if you don't intend for them, or you do intend for them to get the other stuff, be specific in the arbitration provision. And lastly, the type of arbitration award. For larger cases, I always recommend a reasoned award, right? Because if you have any concern about whether an arbitration award is going to be enforced or not, you want the judge to review as detailed an award as possible, where the arbitrator explains exactly how they got to the numbers and the figures they did, right? That's going to give that award the best chance of surviving a vacatur challenge or some other clarification or modification that a judge might issue. So, Andrew, getting back to the discovery issue, unlimited discovery, especially with depositions, can dramatically increase the cost of an arbitration. Should this be limited in the arbitration provision based on the size of the claim, or should the amount of discovery always be determined by the arbitrators? Who do you like to make these calls?
I think when you go into a contract, if the contract is about a large enough amount of money, I think you need to give the arbitrator quite a bit of discretion, because you may have a dispute that is about tens of millions or more, and then you do need to be able to take the depositions you need, and then you need to be able to get the document discovery that you need. I think the area that I see the most variety in, that I think is of concern, that needs to be thought through, is the difference between whether you get third-party discovery or not.
Mm.
Because in 2017, the Ninth Circuit said the FAA, the Federal Arbitration Act, does not allow third-party discovery. In 2015, 2025, the California legislature changed the CCP to authorize arbitrators under the California Arbitration Act to issue third-party discovery subpoenas. So that's the big difference. And if your case is one where enough money is at issue, and you're in California or you're using California law, you want the CAA, California Arbitration Act, to give that power to your arbitrator if third-party discovery is going to be relevant. But I think we have to trust our arbitrators to create the constraints that are necessary in a case, and it's hard to set those in your arbitration agreement if you don't know what the size of the dispute is going to be.
Right. All right. Adam, is the prevailing party clause awarding attorney's fees and arbitration costs something you support, or should everybody be responsible for their own costs? Should the prevailing party be able to recoup all the arbitration costs or just the attorney's fees? And the reason I'm asking you this question, Adam, is because you're on the company side here, and I figure you're the person that hires the corporate counsel to draft some of these contracts, so maybe you draft them yourself.
Yeah, we do. We draft them ourselves.
Yeah.
I personally, I don't support fee shifting provisions,
Okay.
and I know there are good arguments on both sides. I might be in the minority in this position, but as in-house counsel, I always feel that one of my core jobs is to dispose of matters before they reach the stage of arbitration. And if for anybody that is in-house counsel, you might realize, for every one that ends up in arbitration or litigation, there are 9 or 10 that we resolve prior to that happening. So on balance, to achieve that goal, I feel like a fee shifting provision can discourage informal resolution of the matter, especially if the total value of the dispute is relatively low. If both parties realize that regardless of the outcome of our conversations to try to resolve a matter, each party is going to have to pay some amount in arbitration fees and outside counsel fees. In my experience, everybody becomes a little more realistic in the conversations that precede arbitration. And of course, as a matter of principle, we don't settle frivolous claims. Just to avoid having to pay outside counsel fees, I'd always rather pay outside counsel than pay to settle a frivolous or weak claim.
Right.
But the general principle remains the same. I think that a prevailing party clause ends up being disruptive to settlement conversation prior to arbitration. That's just my opinion.
Got it. And like I said, there are arguments for and against it. One of the things we see, unfortunately, in arbitration sometimes is abuse of the cost shifting provision. I've seen situations where one side, let's say, has won the majority of discovery disputes, and they think they're in a good position to win the case. And towards the end of the case, we start to see a lot of associates being added on as new counsel, additional partners onto a case. I call this hours stacking, if you will, right? Done by outside counsel. And so by the time they win their arbitration, they submit this giant attorney fee application with all these people that you have no idea what they did. They just submitted hours, right? They maybe never even appeared in the hearing, right? But you want to prevent that kind of stuff. And to Adam's point, this really cuts down on adding a lot of additional counsel to a case just because they think they're going to get their hours recouped on it.
Mhm.
All right. Let's see here. Let's see here. Next slide, please. All right. All arbitration provisions should have, and you can have a million different things in an arbitration provision. I don't think it necessarily makes sense to have a 3-page arbitration provision in your contract, but maybe a nice paragraph or two. But these are kind of the big 5 that I've selected based on my experience and seeing what is most commonly fought over if it's not clearly explained in the provision. So the first is the rules to be used. And I wrote AAA commercial rules, GM's commercial rules, etc., whatever you're going to use. It's very important. There's no such thing to know that there's no such thing as the AAA rules or the GM's rules. We have specific sets of rules for specific case types. I mentioned commercial usually covers entertainment, right? I have seen situations before where this has been ambiguous and AAA has had to make a call and it's been argued to the arbitrator that it was proceeding under the wrong rules simply because they forgot to say what kind of rules it is. Again, this is going to add to your costs. An example would be we had a case where a partner in a company was forced out of the company for breaking an employment rule. And the argument was, well, it should proceed under the employment rules because they were terminated, their employment was terminated. But actually, it was a partnership agreement, and that's what they had entered into the company with, and partnership agreements fall under commercial. You don't want to have this argument, right? It just costs money. The location of the evidentiary hearing, sometimes referred to as seated arbitration. I mentioned before, it's going to be one city, one state, one city, one country if it's international. Will the arbitration be heard by a single arbitrator or a panel of 3 arbitrators? At AAA, if you are silent on this and you don't include it, it's going to be based on the size of the claim. I believe if it's silent, and the claim is above $3 million, then you have to use a 3 arbitrator panel if the parties can't mutually agree to using a single arbitrator. And honestly, $3 million is not enough money, in my opinion, to have 3 arbitrators on a case. The state whose laws govern the arbitration, again, very important if you've got parties in 2 different states. And then lastly, does the arbitrator have the authority to award attorney's fees and arbitration costs to the prevailing party, and what constitutes those costs? All right, and if we advance to the next slide, I'm not going to read this, but just quickly we'll advance to the next slide. This is a sample arbitration clause that I have drafted that includes basically the big 5 that I just mentioned in it. Like I said, that could just be kind of as a boilerplate language. All right, next slide. All right, hiring the right outside counsel for your arbitration, and I'm sure Andrew and Adam are going to have a good conversation about this. Just so everybody knows, I think it was made clear probably in the program description. Andrew has actually been Adam's outside counsel, and that's why they're speaking with me on this presentation today. So really quickly, define the dispute type and arbitration rules and your business objectives, right? So when you are, deciding on outside counsel, I think it's really important to make sure, if it's an employment arbitration, you probably want an employment arbitrator working on it, right? I mean, I know it sounds common sense, but you'd be surprised. You want to shortlist attorneys and firms with arbitration expertise, relative industry knowledge, and similar case experience, obviously. Obviously, it's important to assess credentials, reputation, and familiarity with arbitrators, because you do not want to rely on outside counsel to be selecting an arbitrator when they don't do a lot of arbitration and they may not familiar with who's doing good work in the space. And I'll just add this as well. When you're interviewing outside counsel, the first question you should have is have you represented parties in an arbitration before? And I think that the next question should be, is this something you do frequently? Because just about every litigator I find out there, if you've been practicing for 10, 20, 30 years, has done 1 or 2 arbitrations. But that's not a lot of experience, right? And then the third thing I would ask is, have you done a AAA arbitration? if it's proceeding under AAA rules? Have you done a JAMS arbitration if it's proceeding under JAMS rules, whichever provider's rules that you might be going after? The rules are different between the providers. There are some similarities, but one thing we sometimes see is counsel either misunderstanding a rule or applying a rule from another provider kind of to the case and getting kind of frustrated with the process. Again, it's going to go a lot smoother if your outside counsel has experience with the particular provider's rules that are in the arbitration provision. Communication style and strategy align with your goals. Some outside counsel, in my experience, I think are very good at updating in-house counsel on what's going on with the case, and kind of understanding the finances of the case. I think sometimes some outside counsel aren't particularly good. If you're in-house counsel, my advice would be you want to be getting routine updates on the status of the arbitration. You don't want things to go too long without talking to your outside counsel, because that's when problems can develop that are unforeseen. You want to make sure that fee structures, budgets, and billing practices are discussed up front. Having experienced outside counsel or hiring experienced outside counsel in a particular arbitration type is really important, especially to give you as in-house counsel an idea of what the budget should be for a case and what something might cost. They're going to be typically saying, like, listen, I worked on a similar case. It probably needs a 5-day evidentiary hearing. We probably need to do 4 depots on each side, this and that, right? So I think it's going to cost roughly X number of dollars. And that's really useful information to in-house counsel. So again, there's no surprises. Conduct interviews and check references to confirm reliability. I mean, I assume Adam probably, before he uses new outside counsel, is kind of doing this in the background, but you just want to make sure you're hiring the best people for the cases. And you want to compare candidates side by side to find the best balance of expertise, fit, and value. It doesn't, just because somebody's the most expensive doesn't always mean that they're the best. And spending a lot of money on outside counsel for relatively small disputes doesn't make a lot of sense. And then you want to finalize the engagement with a clear retainer agreement with all the payment and steps kind of outlined. I think it's also really important for in-house counsel and outside counsel to have a firm understanding of who's paying the arbitration costs to the arbitration provider. Is outside counsel providing money in the retainer for so is in-house counsel providing money in the retainer to outside counsel to pay these bills? Are the bills going to be sent to in-house counsel? Just from an administrator point of view, it's very frustrating when you're on the eve of an evidentiary hearing and we have to basically cancel the arbitration because one side hasn't paid simply because the bill got sent to someone's, company accounts payable box, and for whatever reason just never got paid, right? So that's important to understand that. So let's talk about a couple of questions here. Adam, can you discuss how your company goes about hiring outside counsel for your arbitrations? And then really starting with at what point the decision is made to hire outside counsel. I know sometimes in-house counsel, in my experience, can literally handle things right up until the evidentiary hearing when they might actually hire outside counsel at that point to represent them in the hearing. But just give us like kind of an overview of what your process is with that.
Yeah, I think to your point, every company is a little bit different as to how deeply they go into an arbitration. Here at Fifth Season, and in my experience prior to Fifth Season when I was at Viacom, my litigation team handles all of the claims in-house prior to any formal filing. If we're plaintiffs, once we make a decision that we're going to file an arbitration, or if we're defendants, once the other side has filed an arbitration, we always hire outside counsel. We don't handle any of those ourselves. It's the build up to that process that we handle in-house. And because we do that, a lot of the times by the time that we're involved in the engagement of outside counsel, we have a pretty good sense ourselves of what the key issues are going to be in the case, sometimes what our strengths and weaknesses are. And so we go into that process in the engagement of outside counsel with a pretty good understanding about the case. We have various fee structures that we prefer. As I said previously, we do not favor generally any fee shifting provision, which also helps us be a little bit more creative about our fee structures. We sometimes get competitive bids from multiple firms. Sometimes we don't. We're conscious of costs, but we always want to be fair with our outside counsel. Just like law firms want clients to have a good experience, we want the same for our outside counsel. We don't want to go through a whole arbitration and have the firm that we're working with feel like they are underwater on our case. So for fee structure, I really like incentive-based structures. We always want to reward success, efficiency, share in the success that we have with our outside counsel. If we're plaintiffs, this could be some combination of a discounted hourly rate combined with a percentage of the award or settlement, very common. If we're the defendant, it could be a discounted hourly rate where our counsel can true up to its rack rates if we prevail on a motion or prevail at the arbitration, or some metric that we can come up with together that makes sense depending on the case and the expected outcome. But I'm a big proponent of some combination of sharing in the success of the arbitration with our outside counsel as opposed to just standard hourly rate. And we do like, as you mentioned, phased budgets so that we can have some degree of predictability for internal budgeting, how much the matter is going to cost us at each stage. And there's always variables in that there. We don't control what the other side does, of course, but try to get a good understanding in advance with outside counsel of what kind of costs we're looking at and get all of our interests aligned.
All right. Andrew, can you discuss the process you use when crafting an arbitration budget for your client?
Absolutely. So we generally look at the 5 Ds. Document volume. Do you anticipate discovery fights? Do you anticipate dispositive motions? Depot count, and the anticipated duration of your arbitration. Look at those 5 Ds to figure out the dollars that you want your client to plan for and that you want to work with them and plan for.
Yeah. Excellent. All right. Next slide. All right. So working with outside counsel, select the right arbitrator. So obviously this is very important. The right arbitrator for your case can make all the difference. So in my opinion, and like I said, Adam didn't think it was necessarily as important, but I feel that the right arbitrator for a case is the arbitrator with the correct subject matter expertise. Again, there's a lot of niche things with entertainment. I use the profit participation dispute example, not just because as counsel they might, or when they were attorneys, they might have had experience with it, but they know kind of how to work with, read, like, for example, an expert's report, something like that, understand the accounting that studios use and things like that. But again, that's my opinion. I really think people need to start thinking beyond the quote unquote rank and strike list. And if you have a good relationship with opposing counsel, why not select the arbitrator together? Some of the most well-run arbitrations I've seen, and I know this kind of defies what normal aggressive adversarial litigation is, right? Or arbitration is, because you're supposed to fight tooth and nail for your side, right? And with your client. But believe it or not, sometimes when the sides are getting along, it can have a better result for both sides. So I have definitely seen situations where counsel can be cordial with each other and work on finding a mutually acceptable arbitrator instead of the provider putting together a list and people ranking and striking, and maybe the arbitrator that gets selected is somebody that one side really didn't want to get selected in the first place. You need to utilize an ADR provider staff. The case managers we have here at AAA, the case managers at JAMS, case managers at whatever provider it is, work with these arbitrators day in, day out. They know the types of cases and subject matter that they're handling. So, they spend a lot of time putting together rank and strike lists or even just making casual suggestions of sending out resumes of people you might want to use. So don't hesitate to be specific about something you're looking for. Really important, just because an area of expertise is not on an arbitrator's resume, if you suspect based on the resume that they do have experience in the area, based on where they were an attorney at before, a practice group that they might have been a part of, what you've heard through the grapevine. Don't hesitate to ask the case manager to confidentially reach out to the neutral and say, hey, these parties are thinking of using you, but they want to know about your experience in XYZ area. Do you mind emailing me a quick paragraph that I can send to the parties to kind of supplement that? And then something that, again, rarely we don't see a lot of, but sometimes it happens is jointly interviewing an arbitrator before you decide on selecting them. At AAA, once in a while, the parties will both be on a call, and the case manager will set up a call with, let's say, 3 arbitrators, a Zoom or whatnot. One after one goes, and the parties can ask that arbitrator their experience with certain types of arbitrations. And this is not the time to argue the merits of your case or anything like that, but you can ask them simple questions about their background, and sometimes it really helps. Okay. Andrew, can you discuss how you work with your clients on selecting arbitrators? Do they typically just rely on your experience or expertise, or do they become intimately involved in the process, at least in your experience?
I really want client involvement in that process, especially in the entertainment space. The arbitrator, I like judicial types to be your arbitrator, but the judicial type needs to understand the business. And particularly when you're working with in-house counsel like Adam, who's got deep experience both in litigation and entertainment and deep connections in the space, I want the client heavily involved in that process.
Yeah. And then, Adam, I think you probably already answered this because I think I added to a different question, but just in general, how involved are you in the selection process? And you said, I think before, that you really prefer outside counsel to pick their favorites, if you want to confirm what I just said is true.
Yeah, I mean, yes, absolutely. Ultimately, I have to trust my outside counsel. We hire great outside counsel. As the whittling down process, the rank and strike process is happening. I like to hear the reasons why we prefer one arbitrator over another. Because I've spent a lot of time as in-house counsel, I've participated in a lot of arbitrations with arbitrators, and there are individuals who do specialize in the entertainment industry. So there are occasions when I've appeared before an arbitrator who is on a list. Happens a lot. So like to work with my outside counsel, but ultimately I'm going to trust my outside counsel to choose the right arbitrator.
Great. Okay, next slide, please. All right. So a decision that every attorney team has to make: should in-house counsel participate in the preliminary hearing? So there's some values of participation. Obviously, you want to make sure that in-house counsel is aligned with you as outside counsel on litigation strategy and business objectives. Oftentimes, if they're in the background, they at least know what's going on. If, for example, they attend the preliminary hearing and they have kind of an idea of what the process for the case is going to be going out. Occasionally, the arbitrator might have a question in the preliminary hearing about that they need the client to answer, providing context, history, or internal insights related to the case. Decision-making, obviously, having in-house counsel participate enables for quicker resolutions when it comes to strategy, costs, and settlement opportunities. A good arbitrator on a preliminary hearing call will talk about settlement, will talk about adding into the scheduling order a deadline for mediation or some sort of other dispute resolution. To Adam's point, that's 100% correct. The majority of arbitrations are going to settle prior to the evidentiary hearing, right? And the preliminary hearing is a great time to discuss if that's going to be a possibility. And then obviously, client engagement. It really shows arbitrators the client is invested in the process. I just do think in the back of an arbitrator's mind, when they know that the client is really going to be involved in the process, it might lead to a different result. Obviously, there's a couple drawbacks. One is mixed messaging. If you are outside counsel and in-house counsel is going to join you on the preliminary hearing call, you want to make sure you're both on the same page and not telling the arbitrator different things. And in-house counsel should not probably be doing the majority of the talking in the preliminary hearing, because that was the point of hiring outside counsel in the first place, right? That's diluting kind of their power. And then, of course, there's possible confidentiality concerns and added costs. if, if everybody is just kind of joining this together. One thing I would also say too is you need to be careful with uh, if you're outside counsel and your in-house client or your client, I should say, the company, whatever it is, um, might say something silly. I was about to say stupid during the preliminary hearing that might jeopardize your case. You really have to kind of evaluate if there's any loose cannons within the client's team that could jeopardize the arbitration. Not that Adam would ever do anything like that. I don't worry about Adam. But I've seen some situations where the client's been on the preliminary hearing call and says something that I'm like, did they really just say that to the arbitrator? And their outside counsel had no idea and wasn't able to stop them. Okay, so Adam, do you typically attend the preliminary hearing, and do you let outside counsel attend on their own?
I like to attend the preliminary hearing as an observer. There are occasions where outside counsel says it'd be a good idea for me to speak on an issue. And in that case, as you said, critical that we're fully aligned and that the messaging is fully consistent. Most of the time, I'm there as an observer. And if I have somebody on my team, internal team here on the litigation team, that's more of the lead in-house counsel on a particular matter, I like to bring that person along too. Or if there's a risk of that feeling a little heavy on our side, then sometimes that person will go instead of me. But again, critical, like you said, to align with your outside counsel if there's any expectation that I'm going to speak.
All right. Andrew, and like I said, not using Adam as an example because I know Adam is very professional in preliminary hearings, and he mentioned he likes to stay in the background, not be an active participant. Um, do you want your clients on the preliminary hearing call, or does that, risk the client saying something prejudicial to their case? Especially kind of in emotionally charged bet the company cases, if you've ever been a part of one of those. What do you think?
Yeah, I have never had a situation where the client said something at the preliminary hearing other than something that we had uh, planned ahead of time. I will say that having done a few different preliminary hearings, or they sometimes have different titles in with other arbitration companies, I do like having an opportunity to have just an attorney to arbitrator connection without an audience. So depending on the nature of the case, I may ask the client not to attend because I want to have that kind of one-on-one interaction with the arbitrator, and of course, opposing counsel is there too. But it's very fact specific, and it's more about that the dynamics with the arbitrator than whether I'm concerned that the client's going to say something.
Yeah.
That has not been a concern for me.
Yeah. Okay, next slide. All right, I'm just going to go quickly through this, just because I know we're short on time. I might go a little past the bottom of the hour, 1:30. But anyways, okay, so it's really important to, prior to the preliminary hearing, meeting confer on a couple of different issues. Again, you want to length of the final hearing, witness availability, confidentiality, and protective order requests. And I'll add that the protective order requests really should be worked out between counsel before the preliminary hearing and just ready for the arbitrator's signature, right? There shouldn't be a lot of argument about that. Cybersecurity issues in ESI, you want to make sure clawback protection issues are discussed. The type of award one would expect, usually it's going to be a reasoned award on a big case, but it can be just a simpler or standard award on a smaller case. Which state's choice of law provisions are going to govern? This is really important if it's not spelled out in the arbitration provision and if the parties are in two different states, right? That can be a huge thing that you fight over. Procedural issues, again, are we going to do the FA? Are we going to use the CA, whatnot? Again, there's always sometimes arguments about this. And is there any jurisdictional issues proceeding in the arbitration? So I think it's really useful if one side feels that this case shouldn't be in arbitration and they plan on challenging jurisdiction, to have that conversation and what that's going to look like beforehand, including whether the side that thinks it shouldn't be in arbitration doesn't believe the arbitrator has the authority to rule on jurisdiction and wants to basically file outside litigation related to it. Next slide. Okay, so is the case proceeding under the correct rules? This is particularly important if it doesn't mention which rules are going to be used. Can the scope of the arbitration be narrowed? You'd be surprised just by talking to the other side how many issues you can work out that don't have to be decided by an arbitrator. And are there any issues that can be resolved prior to the preliminary hearing? That's going to save you time and money. Has an early neutral evaluation taken place? I think having an early neutral evaluation or an early mediation earlier in the process makes a lot of sense. Once both sides have done a little bit of discovery, you can start talking about numbers and settlement. Will a counterclaim be filed? It's really important to know if there's going to be a counterclaim because that's obviously going to affect everything from the discovery process to the length of the evidentiary hearing and the overall cost of the arbitration. Is one side going to file some sort of MSJ or dispute for summary disposition? Again, adding to the time and the timeline. Subpoena requests. If both sides say, I plan to subpoena these witnesses, and the other side, I plan to subpoena these witnesses, you should ask the other side if they're going to plan on challenging any of that, because challenges mean it's going to have to go to the arbitrator to decide the dispute, and that's just going to lengthen the process. Has a mediation been scheduled? If so, when? And then this is always the best situation if the parties can sit down. Most providers will send you a model, basically fill in the blank joint scheduling order prior to the arbitration. And if you can sit down with the other side and fill that out, that's going to save a lot of time. Okay, next slide. And again, I'm sorry that I'm going quickly here. All right, during the preliminary hearing, obviously setting page limits on briefing is important. And I would say not just on the briefing, but also on the exhibits. If you set a 5-page limit for a certain type of brief, but they send 200 pages of exhibits, that really didn't save anybody any time. If your legal secretary keeps your calendar, they have to be on the call with you. I can't believe how many times I've seen the preliminary hearing completely wasted because the counsel has no idea what their schedule is. Their secretary keeps their calendar for them, right? That's silly. You want to set the hearing within a reasonable time frame, even if dispositive motions are planned. Just because one side plans to file a dispositive motion does not mean you should not set evidentiary hearing dates on the calendar, because if the dispositive motion is not successfully won, then you're going to have this whole call all over again to get the dates on calendar for the evidentiary hearing. Just set it a little further out. You should discuss discovery, depositions, interrogatories, how many of those, what that's going to look like. Obviously, identifying issues that are capable of being resolved now. Setting a reasonable deadline for dispositive motions. You do not want dispositive motions being filed on the eve or the week before of an evidentiary hearing. That's way too late in the process. I would consider a joint stipulation of facts. If the parties can sit down and put that together, that's going to save a lot of time. And obviously setting a mediation cutoff earlier in the process. And some arbitrators have very exotic cancellation policies that require 30, 60, 90 days in advance of the evidentiary hearing it to be taken off calendar. You want to make sure you don't set the deadline too close to that, because then you might get into their cancellation policy. All right, Andrew, since many arbitrations settle before the evidentiary hearing, when is a case ripe for mediation?
Every case is different, but I generally look at 3 moments: before filing, before depositions start, and then before the evidentiary hearing.
All right, and Adam, if you decide to attend the preliminary hearing, I was going to say, do you attend primarily as an observer or do you participate? But you've already answered that question. You primarily attend as an observer, correct?
Correct.
All right. Next slide. Most arbitration providers have some Oh, I'm sorry. Can you go back one slide? Most providers have some variation of a streamlined panel to hear disputes, and there's a couple of different options here. If the parties are getting along and they don't need, say the contract requires a full 3 arbitrator panel, you simply appoint the chair, and the chair basically handles everything up to the evidentiary hearing. If there's going to be an evidentiary hearing, that's very efficient. Another option would be you appoint the chair and the 2 wing arbitrators, and they all attend, let's say, the preliminary hearing, and then the 2 wings drop off, and the chair handles discovery disputes and whatnot until the evidentiary hearing. Both very efficient ways at doing things, can save a lot of time and a lot of money. So if you're getting along with counsel, especially if it's on an arbitration that has a high degree of potential settlement in advance of the evidentiary hearing, it's a good idea to think about these two options. All right, next slide. Again, so during COVID, we saw a lot of evidentiary hearings going to video hearings. I still see most motion hearings held via Zoom or some sort of video conference platform, but we still occasionally have full-blown evidentiary hearings held via video conference. I'm not going to read each of these bullet points here because I'm trying to keep us on the schedule, but these are all things in your materials that you should pay attention to. So I will just say, and either one of you can jump out of this question, Adam and Andrew. Post-COVID, are you still seeing a good number of arbitration evidentiary hearings conducted via video conference?
You want to take it, Andrew?
Sure. I, I have not seen arbitration evidentiary hearings full video conference. I've seen hybrid or full in person. My preference very much is in person.
Okay. All right.
I prefer in person. Obviously, there's some witnesses that sometimes have to testify over video conference, but I prefer in person. And if there's witnesses that are from my company, I prefer for everybody to be there in person.
And I would say that both of what you've said is what we are seeing kind of in the marketplace as a provider. We are seeing a return to either full in-person evidentiary hearings or hybrid hearings where you have the arbitrator or arbitrators and counsel in person and maybe key witnesses testifying in person, but maybe minor witnesses can testify via video conference in the room or something like that. Makes the most sense. All right. If I was to say Northern California, because I got two Southern Californians on this, has been a little slower than Southern California to come back to in-person evidentiary hearings or full in-person evidentiary hearings, but we are starting to see more of that in Northern California too. All right. And just in general, do you guys think that hybrid hearings make a lot of sense where key witnesses are testifying and then minor witnesses are testifying remotely? Does that make sense to have all the witnesses testify in person, or is it okay to have some witnesses not testify in person?
It's okay to have some more minor witnesses testify via video. I'm fine with that.
Okay. All right. Okay, next slide. All right, drafting a effective pre-hearing briefs. Obviously, you want to set the stage for your case in the pre-hearing briefing. It's really important at this point to keep brevity and succinctness. So you want to have a strong preliminary statement. Drafting a 10-page preliminary statement doesn't make a lot of sense. It should be less than a page. You want to set forth your expected proofs and not overpromise. Again, you should have an idea of your case and what the evidence is that you plan to present, and that should really mirror your pre-hearing briefing. And you really should show the arbitrator that you've learned from disposition rulings. One thing that can be frustrating for an arbitrator is when a lot of stuff is brought up in pre and post-hearing briefing that really they've already kind of decided, and they kind of feel like you weren't paying attention the first time around, right? You want to state the law, focus on key factual issues. It's very important in your briefing, if you're going to provide case citations, to have e-links and hard copies of key statutes and cases, so the arbitrator has all that information there. Some arbitrators are more green. You can just submit this all electronically, and they can follow it on their computer or their iPad, whatever they're looking at the case. Some arbitrators are a little more old school, and they want that printed out trial binder and all that kind of stuff. You're going to ask the arbitrator what their preference is. They usually let you know. And then you should consider in limine motions during the course of the evidentiary hearing, similar as you'd see in court. Andrew, do you have your client read the pre and post hearing briefs before you submit them? Is that something you want their opinion?
100%.
Okay.
Absolutely.
All right. And then Adam, do you read the pre and post hearing briefs for accuracy and for input? Is this something you enjoy doing or is part of your process?
Yes, I do. I do get into the briefing and I read all of it and I give feedback on all of the most important briefing. And if there's one area I probably would, with a little bit of self-awareness that I probably say maybe my outside counsel would prefer less input on for me, is maybe in the briefing. I do get into it. I want to understand all the arguments and I want to give my input. I don't make outside counsel take 5 rounds of notes from me on the briefs or anything like that, but I do like to understand the key issues, strengths and weaknesses. Part of my job as in-house counsel in managing the rest of the internal stakeholders at any company that you work in is to really have a good grasp of the issues. And I find reading the briefing is essential.
Yes. Okay, next slide, please. And we're going to go just a few minutes over, but I promise I'll keep this under 10 minutes for the rest of the presentation. Okay, presenting witnesses and evidence. So we talked about having a joint stipulation of undisputed facts. If we're arguing over undisputed facts, that wastes a ton of time. Fact witnesses, you have to decide if you're going to use direct testimony or their sworn statements. This could be attorney preference or arbitrator preference. You might want to ask the arbitrator what they prefer. But again, statements are going to be a lot less expensive than actually having them there. Expert witnesses consider hot tubbing. So some people might ask, what does that mean? In the old days during an evidentiary hearing, we had the experts kind of come in one by one, sometimes different hours within the same day, sometimes on different days. This all makes the process a lot slower and take a lot more time. So it might make sense if you could have all your experts together on the same day together. That way, you can literally cross them all there when they're all on the stand, right, and get everything all sorted out that way. Using a witness's deposition for submitting depo experts or impeachment, again, I think it's faster with depo experts, but people might have personal preferences to go a different direction on that. And then you need to decide on the arbitrator questioning of witnesses. So some arbitrators will directly ask witnesses questions. Some arbitrators won't. I know that arbitration is a little less formal than court. It's not something that's necessarily commonly done where you see a judge directly questioning a witness. But in arbitration, sometimes we see that. Managing exhibits. So whether the hearing is remote or live, you want to make sure all exhibits are legible and manageable for the arbitrator, both during and after the hearing. This is when sometimes having that trial binder and pointing out the page things might be on is important for the parties and the arbitrator. Consider joint or separate exhibits. I really think if this can be done via joint exhibits, literally everything in the same trial binder, instead of getting a trial binder from each side, it's really going to cut down on time. And considering the wholesale admission of exhibits, this is going to make things go a lot faster, as opposed to having to lay the foundation and to basically admit each exhibit like individually. That just adds to a lot of time with the process. Okay, next slide. All right, closing arguments, and then addressing interest in attorney's fees and costs. You want to go with your strongest part of your case. That's all I can say when it comes to your closing argument. And again, I think being brief is more important than just kitchen sinking that attempt. When you start to kitchen sink things, the arbitrator starts to forget the stronger parts of your closing argument. Post-hearing briefing. Again, shorter is always better, and a good arbitrator will always set page limits, not just on the briefing, but also on exhibits and whatnot. Again, your post-hearing briefing is not the time to introduce new legal theories you didn't bring up during the course of the evidentiary hearing because it can't be crossed, but just really emphasize the stronger points of your case. Attorney fee applications, the arbitrator should basically explain what they're looking for in those applications. If you as counsel have questions or it's not clear for you what you should put in those attorney fee applications, please ask the arbitrator. The idea of an interim award versus a final award. In most large cases, especially where attorney's fees and costs are going to be awarded, you will see the arbitrator issue an interim award first, basically saying this is the side that won the arbitration and this is what they get. And then the sides will be basically the winning side can work on their attorney fee application. And then a final award will be issued once the arbitrator has reviewed that. That's very common. There are occasionally situations, especially where the parties are very hostile towards one another, where the arbitrator doesn't want to deal with the backlash and all the issues that are going to come up between the interim award and the final award, and they might go straight to a final award. So in that case, the arbitrator at that point will ask, with the post-hearing briefing for each side, assume that they had won the arbitration and submit their attorney fee application costs at that point. And then lastly, this is something that I always love to see if the parties are working really well together. Should the parties draft a model final award after the interim award is issued? Meaning let the parties work out the issue on attorneys' fees and costs amongst themselves and literally just fill in the blank as far as what both sides think is fair as far as for being compensated on those issues. Again, it's rare that the losing side is in a good enough mood to want to participate in drafting a model final award, but in the end, it's going to save a lot of time and costs so you don't have to pay the arbitrator for their time going over arguments on an attorney fee application. Okay, Andrew, attorney fee applications and the associated costs of arguing them can greatly add to the cost of an arbitration. If you're the prevailing party, do you typically attempt to reach out to opposing counsel and see if a consensus can be reached on what you are owed before submitting the application to arbitrators? Have you ever attempted this?
It's a great idea. I have never done it for the reason that you mentioned, which is by the end of the process, there's a lot of hurt feelings or can be. And so I have not found it to be productive. But what I will say is that we use rates that are not controversial in the industry. So we don't generally, we're not using expert witnesses to validate rates and the like. And that does help to keep costs down when we submit the application to the court or the arbitrator.
Okay. All right. And Adam, if you're hopefully on the winning side of something and you're entitled to attorney's fees or attorney's fees and arbitration costs, let's say the arbitrator reads Andrew's attorney fee application and decides to shave off a couple of hours from it. Do you typically ask outside counsel to write off those hours because they weren't awarded, or are you just in a good mood and figure I might as well pay the full legal bill?
Yeah, I've never done that.
You've never done that.
I've never asked outside counsel to keep the context, as you pointed out. This is a situation where we've won an arbitration and now we're sorting out recovery of our fees. And I understand that sometimes for a lot of different reasons, there's less than the full award of fees and costs. There's a lot of reasons why that can happen. And I'm also very careful throughout the process of managing with outside counsel the fees as they're being accumulated. So I rarely want to be in a position where I'm so surprised that there's such an excessive amount of outside counsel fees or costs that despite winning, I'm asking my outside counsel to shave down their fees. So I've never done that. Never been in that situation before.
Excellent answer. You're clearly very good at managing outside counsel, I can tell. Okay, last slide. Next slide. And I'll try to get through this as quickly as possible. Okay, enforcing and vacating arbitration awards. So this process is usually the attorneys file a petition in federal or state court to confirm the award. Under the FAA, you have a year to do it, but it's pretty standard. Courts give strong deference to arbitrators in the awards that they draft. So pretty much enforcement's going to be automatic unless there's a serious issue raised. Usually, where I see arbitration awards getting vacated is if there was a failure to disclose issue where the arbitrator has some conflict with one of the sides, and it's a significant enough conflict that a judge feels that they were biased in the decision making. Once confirmed, the award becomes a court judgment enforceable like any other order. All know this. And then vacating award is difficult and really has to be sought within a couple of months of issuance. The longer you're waiting on to decide whether you're going to vacate or not, the less chance you have of doing it. Again, grounds for vacature are limited to corruption, fraud, evident partiality, right? Arbitrator misconduct, or exceeding arbitral powers. Not following the arbitration provider's rules to the T, arguing about legal theory and things like that. These are things that people try to toss out there to get an award vacated, but they almost never work, right? So really think about how strong your vacature application is going to be. And remember, courts are not allowed to vacate for mere legal or factual mistakes, unless really there's a chance that it would have completely changed the decision. Okay, my last questions to Andrew and Adam. Andrew, can you briefly discuss the enforcement vacature process from outside counsel's perspective? And in your experience, would the same attorney team that handled the initial case be also responsible for enforcing or vacating an award?
Absolutely, you want the same team involved for efficiency reasons. I find that moment of vacatur or enforcement is a big strategic leverage point. If the arbitration has been confidential up to that point, especially in the entertainment space, then the parties are going to be facing whether this becomes public or not, and that can sometimes be an important leverage moment for the parties.
That's right. And then, Adam, I would say how much involvement from the client perspective, how much is in-house counsel involved in the enforcement or vacature process? And is it sometimes handled in-house, or do you want Andrew to bill a couple more hours and you hand it back to him?
Yeah, like for the reasons Andrew pointed out, it's much more efficiently handled by outside counsel. I don't handle that process in-house at all, other than, of course, managing internal expectations at my company so everybody understands that this is a process and sometimes it takes a little longer than to have the proceeds than we might otherwise expect. That's my job as in-house counsel, and I'm going to obviously defer to and trust my outside counsel to handle the process.
Okay, if we can go to the next slide real quick. So I'm going to apologize to everybody for running over. I know there were some questions in the chat, but I want to give everybody back the time that we've taken from them. So if you have any questions or anything like that that we didn't get to that you'd like me to answer, this is my email address. And that's how you can reach me. I'd like to thank David as chair of the section for taking the time to do our introductions today, and I'd like to thank Adam and Andrew, who are extremely busy, I know, for taking some time out of their day to speak with me. So it's been great. Just thank you guys for joining.
Thank you, Aaron. Appreciate it.
Thank
Bye.
you. Thank you, David.